discovered this writ and convinced his boss to take it.
Do you know the clerk's name?
I don't remember. It's probably in the article by
Okay.
Masnier.
And so one of Justice Doug, I stopped recording. Sorry, one of Justice Douglas's clerks said you should take this case.
Yeah, it had been overlooked by everybody else, but this clerk called it to Douglas's attention later on, and late in the day, and Douglas took it on. So then we went up to court, and the position of the state attorney general, I guess, realized he had a losing proposition on his hand. He elected not to go and sent the state assistant attorney general, who was young and inexperienced, to argue the case for him. But it was fair game, because Wade Penny was a brand new graduate from law school, never been out of the state, in fact, let alone argue before the U.S. Supreme Court.
Wow.
And because the ACLU, they did file a amicus brief, but they didn't write the argument. So he had to do that on his own, though Renolstein did help him, of course. So anyway, the position the state of North Carolina took was that this was a trivial matter, had no real significance, and they couldn't understand why the court would bother to deal with such a matter. So at that point, Justice White started asking an interesting series of questions. Said, if the defendant wants to go abroad in filling out an application for a passport, this was still in the post-McCarthy days, don't forget, he's asked if there are any criminal proceedings pending against him. Wouldn't he have to say yes? Well, yes. Might not that be a disadvantage? Well, yes, possibly. If the defendant applies for federal funds to support his research, he will be asked if there are criminal proceedings, and so on.
Right.
So he went through this litany 4 or 5 times. If he did this and this. And at one point, Andy Veneer, the assistant attorney general, sort of, probably sort of looked around as if looking for help. And at that point, Earl Warren, in this avuncular fashion he leaned forward and said, "Young man, if you would like time to confer with your superiors, I will give you that." And at that point, Justice Douglas leans back in this big rocker of his, slaps his hips, and lets out a loud guffaw. I could hear it on the tape. Ha! And Van Alstyne, who's sitting next to me, rams me in the ribs with his elbow. Says, "We've won. We've won." And then the assistant attorney general declined the offer to confer, and the Warren then asked, "Does the state wish to concede the case?" And he said, "No, Your Honor, we do not concede." And that ended the trial.
I haven't listened to the whole thing. I'll send you the link as well if you want to listen to it. But I'd love to find that spot. So that happened in December.
Yeah.
And then the actually, I mean, you knew it was going to happen. Probably. I mean, you didn't know. You were pretty.
I didn't know, but Van Alstyne, he's a savvy lawyer. He'd been in the Supreme Court many, many times. I figured if he was confident we'd win, we'd won. So I stopped worrying about it.
And then you actually won in March.
Somewhere then, yeah. I got a call from the New York Times, or was it Time Magazine? One or the other. called me. My secretary took the call, said, "I have a call for you. I think you will want to take it." Normally, I never took calls during the working day. I let my secretary deal with these things. "I think you want to take this call."
Now, so I was doing a little research. I found an article in the Chronicle that was from September. They still hadn't dismissed the case because they went on a break.
That's right.
In Orange County.
That's right.
And then it came back in August. When did you finally get free of this? Do you remember?
I don't think I'm not even sure that I had to be there.
So I was wondering, did you have any sort of a celebration to
No.
mark it's just, okay.
No.
And then it ended up setting this precedent, incorporating the Sixth Amendment.
Well, that was where the big surprise came. No sooner had the decision been announced that Wade Penny, my lawyer, phone started ringing nonstop. Turned out that while the null pros with leave in North Carolina was indeed unique, lots of other jurisdictions had a similar unnamed practice.
Huh.
In New York, it turned out, it was almost de rigueur. If you were arrested and the DA wasn't convinced that he could get an easy conviction, he would offer you a chance to enter a plea for a lesser crime, a guilty plea for a lesser crime, or else you could stew in jail and wait for him to get around to bring you up to trial. They didn't call it null pros with leave.
But it was
They
effectively
just
the
said,
same
"Oh
thing.
yeah, takes time to get around to try you. You want to get a speedy trial? Well, you plead this, guilty for this, then I'll take care of you right away."
And that then stopped. Theoretically.
It stopped. And because one after another, the courts ruled, "You've been in jail for 3 years for this?"
Wow.
And courts generally, taking the view the more serious the crime, the longer the court was entitled to delay bringing you to trial so as to get all their ducks in a row. The less serious the crime, the less time the courts could expend before calling your case up. And so the effect of this ruling was momentous. Literally thousands and thousands of cases were dismissed as a result of the enforcement of the right to speedy trial.
That's great.
But we hadn't anticipated that.
Yeah.
And the ACLU's face was very red when they realized that they had totally misjudged the significance of the case, of the ruling.